One more chance.
Let me ask you this. Have you ever reported?
No, ma'am.
So you have been on probation since 2022 and you never reported. So are you telling the court it's taking you 2 years to get a phone? Because we're in 2024.
Yes, Your Honor.
Elizabeth Anne Gaskin walked into a Texas courtroom in 2024 asking for one more chance. What the judge said back to her would leave the entire room in stunned silence. And it started with a single devastating question: have you ever reported to your probation officer? Not once, not ever. 2 years. That's how long Gaskin had been on probation for unauthorized use of a vehicle, a felony charge stemming from March of 2022. 2 years of court-ordered supervision. 2 years of monthly check-ins that exist for one reason: accountability, the legal requirement that a person convicted of a crime answer to the system that gave them a second chance instead of a prison cell. And in those 2 years, according to her own admission under oath, Elizabeth Gaskin reported exactly 0 times. This is the story of what happens when the system's patience runs out, and when a judge decides that mercy, offered once already, is not a renewable resource. The case itself began quietly.
Could I have someone from the state? It's Criminal Trial Division.
Yes, Your Honor.
Court is calling 2021 CR 4146, State of Texas versus Elizabeth Anne Gaskin. Can I have parties announced for the
In
record?
2021, Gaskin was charged in Bexar County, Texas, with unauthorized use of a vehicle, essentially taking someone's car without their permission and driving it. It's a felony, but prosecutors and the court extended her deferred adjudication, a legal arrangement that lets a defendant avoid a formal conviction if they complete probation successfully. No prison time. No criminal record. As long as she followed the rules, it is, in plain terms, the legal system's version of a clean slate, provided you actually show up for it. She didn't. By 2023, the state filed a motion to adjudicate guilt and revoke her community supervision, alleging she failed to report to her supervision officer for 5 consecutive months, May through September.
Gaskin,
Yes, Your Honor.
did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
That's the violation she pleaded true to in court.
This is in the first motion to enter adjudication of guilt. Violation of condition number 4, Bexar County, Texas. The defendant, Elizabeth Anne Gaskin, then and there failed to report to the supervision officer as directed for the months of May, June, July, August, and September 2023 in violation of condition number 4.
How do you
True,
plead,
in legal terms, means an admission. Not innocent, not contesting it. True.
how do you plead to that? True or not true?
True.
Did away with the other allegations.
Any objection to the state's waivers?
No objection, Your Honor.
She knew what she had done, and she said so under oath, after being placed under oath and warned that her testimony had to be the truth and nothing but the truth.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
But here's where the story gets complicated and where most viewers' sympathies will start to shift. This was not Gaskin's first time standing in front of this exact judge for this exact violation. It happened before. In November of 2022, she was hauled in on an earlier motion to revoke for the same failure to report. The judge, instead of revoking her probation then and sending her to jail, denied that
And I'm
motion.
willing.
So you were here in Bexar County on a motion to revoke for the same violation that you're here now. And it was a violation of condition number 4. I denied the motion. Alternate monitoring conditions to include the UA hotline until further notice and weekly
She
reporting.
gave Gaskin a second chance, alternate conditions including a UA hotline requirement and weekly reporting.
Weekly reporting until further notice. So that was in November 2022. And when I gave you those rules, you still didn't report. So
A second chance is a legal mercy, not a legal entitlement. Courts are not required to extend it once, let alone twice. So when Gaskin appeared back in that courtroom in 2024, the question on the table wasn't really about a single missed report. It was about a pattern, and patterns in a courtroom are where credibility goes to die. Her defense attorney made the case any reasonable person might expect Gaskin lived in Dallas, not Bexar County, and the distance made consistent reporting difficult. She'd lost her phone. Her living situation had fallen apart. He asked the court to consider transferring her probation to Dallas, where she could complete it closer to home, possibly even checking in by video call in the
See
meantime.
that there was a previous MTR when she had come down here. She had kind of messed up her living situation in Dallas. She lost her phone, so she wasn't able to continue reporting. She understands, that it was on her. She could have gotten a phone and found a way to access these people and, make the calls that she needed to make. But she, like I said, her living in Dallas, she believes that being able to complete this probation there would give her an opportunity to get the help.
It's a sympathetic argument. Plenty of people watching this will recognize the shape of it. A system that demands compliance without making compliance realistically possible. Anyone who's ever been stuck on hold with a government office or punished at work for a policy nobody bothered to explain to them knows what it feels like when the rules are rigid and your circumstances are not. Then Gaskin spoke for herself.
Say,
Oh, sorry.
you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Elizabeth Anne Gaskin.
What do you wish to say?
Under
Oh,
oath, she told the judge she now had a working phone, she was willing to do video check-ins, and she genuinely wanted, by every appearance, to complete her probation the right way. I do want to do right with my probation, she said, and I just wish that you would give me one more chance.
Transfer to Dallas first, and that's fine. I'm willing to do that. I do have a phone now, and I am able to do Zoom visits for it to be transferred to Dallas, and then it'll be way easier for me to report and not violate. Because I'm not trying to run. I do want to do right with my
It is,
probation.
on its face, a reasonable request. It is also where the judge's questioning turned forensic. Have you ever reported? The judge asked. No, ma'am, Gaskin answered. So you've been on probation since 2022, the judge continued, and you're telling this court it took you 2 years to get a phone. It's 2024. The defendant tried to qualify the answer. The phone had been on and off, stolen more than once. But the judge wasn't finished.
Yes, Your Honor, I'm aware of that, but it's,
No. My question is, has it taken you 2 years to get a phone?
no, ma'am, but it's on, I've had a phone, but it's been on and off because it's been broken and it's been stolen from me.
This is the moment that defines the entire hearing, the one clip that will be shared and replayed because it needs no context to land. The judge pointed out that Gaskin had been able to borrow money from her own father for a Greyhound bus ticket to Dallas immediately after being released under court order to report weekly, but couldn't borrow that same father's phone to make a single call to her probation officer. You can find a way to leave the county, the judge said in substance, but not a way to check in with the court that's supervising
How did
you.
you get to Dallas?
I had to borrow money from my dad to get a Greyhound bus to get back. to
Okay, so
Dallas.
you can borrow money from your father to get a Greyhound bus, but you can't use his phone to check in with probation?
I have no family in Dallas.
No.
That's not a legal technicality. That's a credibility collapse delivered in real time in front of a packed docket.
So let me ask you this. How did you get from Bexar County to Dallas? Did you immediately, after I told you to report on November 28, 2022, when you were released, did you immediately go to Dallas?
Yes, ma'am.
How did you get to Dallas?
Here's where the legal stakes get serious and where the education matters as much as the drama. When someone is on deferred adjudication, the conviction itself has been deferred, postponed, contingent on compliance. Violate the terms, and a judge doesn't just have the power to punish the new violation. She has the power to adjudicate guilt on the original charge entirely, treating the case as though the deferral never happened, and then sentence the defendant on the underlying felony as if it were fresh. That's exactly what was on the table here, not just a probation violation penalty, but a full felony sentencing with a range up to 2 years in a state jail facility and a fine of up to $10,000. The prosecutor wasn't asking for the maximum. The state requested 180 days, the legal minimum available under that range.
State, what are you requesting?
We're asking the court to grant the motion to adjudicate Ms. Gaskin and to sentence her to 180 days in a state jail facility.
All right.
And that's when the judge asked the question that should make every viewer sit up straight. Why should I give you the minimum? You've done nothing, the judge said, to earn it. The only thing you did was take someone's vehicle without permission.
Court is going to revoke. The state is asking for, how much time are you asking for?
180 days.
Why should I give you 180 days? 180 days is the minimum. You have done nothing.
And you
The only
haven't done anything since to show this court you deserve leniency. You're not 18. You're
days
30
is the
years
minimum.
old.
You have done nothing. The only thing you did was take someone's vehicle without their permission and go on a joyride on it, and you haven't done anything. And it's not like you're 18. So why should I give you the minimum for a case where you did absolutely nothing?
Pause on that for a second, because it's worth asking yourself directly if you'd been given a second chance after already breaking the rules once, and then proved for 2 straight years that you wouldn't follow even the most basic requirement, a phone call once a month, would you expect mercy a third time? Or would you expect the system, finally, to stop extending credit it had already proven you wouldn't repay? There's no clean answer here, and that's exactly the point. What the judge did next was the twist nobody in that courtroom saw coming. The state asked for 180 days, the floor. The judge didn't go to the floor. She went to the ceiling.
That's my question for you.
I don't have an answer, ma'am.
All right. So the court is going to sentence you to 2 years in the state jail facility, give you credit for any time served.
2 years in a state jail facility. The maximum sentence available under the charge handed down not because the prosecution pushed for it, but because the judge, on her own authority, decided 180 days didn't reflect what had actually happened in that courtroom. That's a critical thing to understand about American courts. Judges are not bound by what prosecutors recommend. A plea or a sentencing request from the state is persuasive, not binding. The final number belongs to the judge alone, and in this case, the judge used that authority to hand down 4 times what the state had asked for. It's a partial justice, and an uncomfortable one. Gaskin got real consequences, the maximum allowed by law. But it's also fair to ask whether 2 years in state jail actually solves the underlying problem that put her there in the first place, a young woman without stable housing, without a reliable phone, without family support in the city where the court demanded she remain. The system held her accountable. Whether it helped her is a separate question entirely, and one this verdict does not answer. Before sentencing her, the judge also confirmed something easy to miss. A felony conviction strips a person of the right to own or possess a weapon or ammunition for life, unless that right is later restored through a separate legal process. That's not a punishment handed down by this particular judge. That's federal and state law attaching automatically the moment a felony conviction is entered. One more permanent consequence layered on top of the prison time, quietly mentioned almost as an afterthought, but lasting far longer than the sentence itself.
That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
This is a felony conviction. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to
The lesson
speak
here isn't really about Elizabeth Gaskin specifically. It's about what happens when second chances run out, and about the uncomfortable truth that courts will often forgive once, but rarely twice, and almost never a third time when the pattern is this clear. The legal system isn't designed to punish people for circumstances beyond their control. It's designed to test whether someone will do the bare minimum to show they're trying. In this case, the court decided 2 years of silence answered that question on its own.
So what have you done that would warrant you remaining on probation? Have you done anything?
No, ma'am.
So, I mean, there's no reason for me to continue on probation, and I'm not going to continue you on probation.
If
All
this
right,
case raised questions for you about how probation actually works, or whether judges have too much power to override what prosecutors recommend, that's exactly the kind of conversation worth having in the comments below. Tell us what courtroom moment or case you want broken down next, subscribe so you don't miss the next one, and share this with someone who needs to understand how these decisions really get made.